I love this association from the core of my heart. I will continue to donate BDT 1 lakh in the month of January every year during my lifetime. You know, 3 international judicial bodies are situated at The Hague in the Netherlands. You see, Amsterdam is the official capital of the Netherlands, but the administrative capital of the Netherlands is The Hague. Our embassy is also situated at The Hague. Hague is a city of peace and justice. This, Permanent Court of Arbitration is also called International Court of Arbitration. This PCA was founded in 1899 by the Hague Convention of 1899. Subsequently, the Hague Convention of 1899 was revised by the Hague Convention of 1907. Bangladesh is a state party to the Hague Convention of 1907. There are 3 key components of the Permanent Court of Arbitration, or the PCA. Number 1, there is an administrative council of the PCA. The president of the administrative council of the PCA is the current foreign minister of the Netherlands. The other members of the PCA are the ambassadors of different countries of the world who are accredited to the Netherlands. Number 2 component is the members of the PCA. And the number 3 component is the International Bureau. This International Bureau is called the Secretariat of the PCA. Mr. Marcin Jipilak is the current Secretary General of the PCA. He is a Polish gentleman. Previously, he was the ambassador of Poland to the Netherlands. The main function of the PCA is the determination of interstate disputes through arbitration, mediation, and conciliation. You know, the PCA, the Permanent Court of Arbitration and the International Court of Justice are housed in the same building. The building is called the Peace Palace. There is another international judicial body at The Hague that is called ICC, International Criminal Court. As I've already told you that the PCA and the International Court of Justice are situated at the Peace Palace in The Hague. But the International Criminal Court, ICC, is situated at The Hague, but it is a few kilometers away from the Peace Palace. Arbitral proceedings at the PCA are carried out through the arbitral rules of 2012. You see, our Arbitration Act of 2001 is predicated upon the New York Convention of 1958 and the UNCITRAL Model Law of 1985. Law, as you know, is a mixed concept and has often different and complex philosophies. Yet law is one of the concerns of the civilized humanity because it offers protection against tyranny and anarchy. But in spite of the coexistence of various legal philosophies, the concept of law is more easily understood than defined. Over the years, the legal philosophers have disputed and the lawyers have debated as to the meaning and purpose of law. The purpose of law is, of course, the success of justice. If law fails to ensure justice to the litigant people, then it becomes a dead letter. Judges are charged with saying what the law means. When they speak, the force behind the law begins to operate. But you see, the judges can't establish the rule of law single-handedly in this country. The other concerned agencies and stakeholders must play their due roles in this regard. Otherwise, establishment of the rule of law will remain a far cry and a piece of music of the distant drum. I take this opportunity to say a few words about the bench and the bar. It is often said that the bench and the bar are the two sides of the same coin. They go hand in hand. They go together. Both the judges and the lawyers are imbued with the same jurisprudential ideas, albeit their roles are different. In that view of the matter, any propensity of either side to carry its temporary ruffled feelings against the other to an unreasonable length destroys the moral foundation of both the institutions. So both the judges and the lawyers should be on their guard to see that the moral foundation of the bench and the bar is not destroyed in any manner. The best judgment of the court, I must say, is the product of the finest submissions made by the bar. But unfortunately, there has been deterioration all around, affecting the quality of justice. According to the observation of the Indian Supreme Court in S.P. Gupta's case, the lawyers are equal partners with the judges in the administration of justice. So it is seen that the role of the lawyers is no less important than that of the judges in the dispensation of justice. In the day-to-day judicial work, the judges are often faced with two self-contradictory, self-defeating, and paradoxical legal dicta. That is to say, justice delayed is justice denied, and justice hurried is justice varied. In my humble view, a fine balance has to be struck between the two, paving the way for dispensation of justice on time. The judiciary is the guardian of justice, the shield of the vulnerable, and the compass of democracy. Nowadays, we hardly come across well-structured, well-considered, and well-reasoned judgments. Reasoning is the pole star of a judicial decision. Without reasoning, the judicial decision becomes lifeless, vapid, and jejune. Every judge should try a case, whether involving the Prime Minister or a man in the street, with equal rigor. As the judges don their robes every morning, they should remember the words of our Constitution. The Republic shall be a democracy where all fundamental human rights shall be guaranteed. This guarantee should begin with the judges. Let us build a judiciary where a garment worker in Sylhet or a van driver in Dhaka or a street vendor in Kulla alike can say, we trust the court, we trust the judiciary. The journey is strenuous, arduous, taxing, demanding, and exacting, but the reward is immeasurable. You see, judicial independence is the lifeblood of constitutionalism in a democratic polity. What is meant by the expression judicial independence? Judicial independence means independence of judicial thought in the decision-making process. When it comes to judicial independence, the perception of the people is very important. If it is the perception of the people that the judiciary is functioning independently of the executive and the legislature, then it's all right. But if it is the perception of the people that the judiciary is not functioning independently of the executive and the legislature, the judiciary will stand nowhere. The judges of the district judiciary shall remain under the sway and influence of the executive unless and until Article 116 of the Constitution is restored to its original position of 1972. You have heard the name of the late lamented Chief Justice Syed Mahbub Murshid. He was a very bold judge. He was a very bold personality, both on the bench and off the bench. He is a lighthouse to many of us. He was a multifaceted and multi-splendid judicial statesman. According to him, I'm going to quote him verbatim, according to him, no tyranny is worse than judicial arbitrariness, and no misfortune is worse than judicial subservience. This is a very insightful comment made by Chief Justice Syed Mahbub Murshid of the then East Pakistan High Court. He made a lot of contribution to the constitutional jurisprudence of this country by delivering landmark judgments in Minister's case, Zakir Ahmad's case, Basic Democracy case, and so on and so forth. Judicial independence, in my humble view, is a mental state of the judge. As you know, the judges of the Supreme Court are institutionally independent, but are all of them mentally independent? The answer is obviously in the negative. All the judges of the Supreme Court, though institutionally independent, are not mentally independent. So, in my opinion, independence of the judge is his mental state. Judges must be made of sterner stuff. A judge must be a bold person. Boldness is an integral part of the personality of a judge. The success of a judge depends upon the absolute confidence of the people in his court. No matter whether he is a judge of the Supreme Court or an assistant judge. Francis Bacon has said, judges ought to be more learned than witty, more reverent than plausible, and more advised than confident. Above all things, integrity is their portion and proper virtue. Francis Bacon has summarized all the sterling virtues of a judge in this pithy comment. I do not deserve the eulogy that has been bestowed upon me by different speakers. I do not deserve the encomiums that have been showered upon me by different speakers. I am a humble person. As a judge, I try to dispense even under justice to the litigant people without fear or favor, ill will or affection. You see, the horizon of the writ jurisdiction of the High Court Division is being expanded through judicial activism with the passage of time. This judicial activism does not mean judicial high-handedness or judicial extravagance or judicial populism. The Supreme Court should take care to see that judicial activism does not lapse into judicial overreach, because judicial overreach is violative of the doctrine of separation of powers between the three organs of the state. What is important for the Supreme Court of Bangladesh is adherence to constitutional morality. By constitutional morality, we mean adherence to the core principles of the Constitution. A judge is a judicial statesman. Judicial competence is the core of this craftsmanship. A judge is a creative artist. His works of art are his judgments. A good judge, or for that matter, a good lawyer, is never made in a day or two. There's a continuing process. There's an ongoing process. If somebody wants to make a good judge or a good lawyer, he must make sustained efforts for it. You see, judges live through their judgments. So their judgments must be of very high standard and show proper appreciation of the laws and facts involved. At this juncture, I feel tempted to quote a few lines of Robert Frost, an American poet. The woods are lovely, dark and deep, but I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. As a matter of fact, we have miles to go in establishing the rule of law in this country. I am already on the wrong side of 70. I am almost 73 years of age. In that view of the matter, I am a septuagenarian. In this regard, I am reminded of a famous line of Browning, an English poet. Grow old along with me, the best is yet to be. So elderly people like me should not feel disheartened or dejected at the aging process, because in the words of Browning, the best is yet to be. I express my heartfelt thanks to the organizers of this event for inviting me and affording me an opportunity to say a few words here. This is undoubtedly a rare moment in my life. This is a defining moment in my life. The memories of this event will remain embedded in my mind and resonate with me throughout the rest of my years. There goes an age-old adage, eat to please thyself, but dress to please others. Hopefully, we will eat to please ourselves. Thank you very much. Thank you all.